right to suggest that the excitement that followed the enactment of the Administration of Criminal Justice Act has considerably whittled down. And why would that be so when all major stakeholders agree that the Administration of Criminal Justice Act contains the main ingredients that Nigerians need to move its administration of criminal justice forward? Some people have suggested that the Nigerian attitude has again come to play, as in most cases where we expect the law to bring up a magic in the society, and it does not. It is the Nigerian person that makes the law work. The law does not work by itself. And so on the scale today, we look at an effort that is being made to re-energize the Administration of Criminal Justice Act and see whether we can reassess its usage and move forward from there. Welcome to The Scale. I am Femi Okeowo. The Administration of Criminal Justice Act is one law that has united Nigeria in the prosecution of crime. Before now, Nigeria had always had two major laws governing its prosecution of crime, either in the northern part of Nigeria or in the south. But with the enactment of the Administration of Criminal Justice Act in May 2015, Nigeria now becomes an entity in the prosecution of crime. But even then, the results that Nigerians have expected are not forthcoming, because people say that the attitude of people, either the courts or the lawyers or indeed the other arms of the justice sector, the police, that's the investigation processes, are not up and doing. There are people who think that the Administration of Criminal Justice Act comes with some recommendations which have not been carried out. And so on the scale today, we go into a function that sought to assess the Administration of Criminal Justice Act in the close to 2 years of its implementation, assess it and see whether it is doing well or not, make suggestions as to how it moves forward, and then also appreciate people who made that act come into existence in the first place. That was done through an award. Aliu Tukur is our guide to that event.
Over the years, Nigeria's criminal justice system has lost its capacity to respond quickly to the needs of the society. In line with the clamor to promote speedy dispensation of criminal justice in the country, Akin Olujimi, upon resumption of office as the Attorney General of the Federation and Minister of Justice in 2003, assembled a team of experts with the sole aim of harmonizing criminal practice and procedure as applicable in the federal courts. It was to also ensure that the criminal justice system promotes efficient management of criminal justice institutions, protection of the society, and the rights and interests of the suspect, the defendant, and the victim.
I was very much aware that we had issues with the trial of criminal cases. Cases could end, take 10 years, even more, before they can be concluded. Now, when I came in, the very first thing that I thought of is, okay, what can I do in this area, of our law? So I empaneled, a committee, and I'm happy today that one of those who worked for me at that time, is here. Actually, George, of course, was my senior special assistant, and he was very, very knowledgeable, in this area. Wale Fakunda, a close friend of his, also very knowledgeable, also came up. And then, of course, we extended, the coverage of the committee, and I had more hands on it. Chinoye Obiagul is here tonight. He did a wonderful job. Now, the idea is that, look, if you have crime increasing on a daily basis, and you cannot get those you are able to arrest, tried, and either found guilty or released, now you have congestion in the prison. That's created a huge problem. In fact, the congestion there was caused not by those who had been tried and convicted, but those who were awaiting trials. And number kept on growing every day because criminals are busy every minute of the day. And when they are picked up, the very first thing you do is, okay, keep them somewhere. And so prisons built for, say, 1,000 inmates now have to harbor 20,000. So this, again, was an issue. In fact, at that time, I had to say, look, let us engage lawyers from private practice. The kind of fees I approved to be paid to them was very, very low, but because, you see, I wanted to bring them on board to decongest because we had quite a challenge there. So to decongest the prisons means getting, you see, a quick means of attending to cases which are pending. So we had to do that. Now, at the time when the committee now worked, they prepared a draft bill. Of course, again, it had to take time. You had to make sure that the bill you were sending to the National Assembly, you see, was good enough to be passed. We had some delay in getting the bill passed, but eventually, you see, it has been passed, and that is what we are now using today. After going through, you see, a lot of contributions here and there, today we have it in use, and it's helping quite a lot. But we still have a lot to do. I can say that because I'm still a practitioner of the law.
After coming up with a draft in 2003, the battle for its passage began at the National Assembly until 2015, when the administration of the Criminal Justice Act was signed into law in May. The Act had 495 sections divided into 49 parts, providing for the administration, criminal justice, and other related matters in the courts of the Federal Capital Territory and other federal courts across the country. With the passage of the Act, many believe that the defects in the Nigerian system of criminal justice administration had been cured, but thus far from it, as almost 2 years after its implementation, observers say not much has changed due to many challenges which include constitutionally related barriers and human attitude.
You see, every day we hear comments from people who are outside the law. They say, cases take too long to get completed. Now, when you go to court, any court you go to in Nigeria today, you may find on the table cases listed which run up to maybe 10 or 20. Now, if each of these cases would have to be attended to, obviously, you will probably need about a month or more, you see, to run through the list and they hear them in bits. Now, it is not possible for a single judge to do all that. You have to think of, and it's very, very important, you see, employing more judges. That is inevitable. You cannot rush those who are now sitting as judges, you see, beyond what their strength as human beings can take. You have to bear in mind they are human beings, and they cannot work, you see, every hour of the day until the next day. They must break at some point in time. Otherwise, you start having tragedies, and may God forbid that. So we need not only, you see, to get the equipment they would work with, but you also need to increase the number of judges. Government has to appreciate that. It's very, very important. It's inevitable. If you don't do that, and you have these reforms spread out, you see, in the books, they are just there, you see, as a means of achieving progress and speedy trial. But when you don't have the human beings that will move these reforms, see, to fruition, it should be like we are just deceiving ourselves. So there must be a way of getting government to appreciate, and I'm happy that the Vice President, who has been involved for several years, you see, in the reform of the criminal justice system, has one of his aides here tonight, who would also carry this back to him. We must put very, very vigorous effort, you see, into strengthening the judicial sector, if we really mean to speed up the trial of cases.
Apart from the penalties, even the rudiments of the procedure. You talk, for instance, about crime data or statistics. If, as it is now, the police does not have a crime data registry, how do you think that makes sense in the act? It can't really be translated into reality. So you have a lot of provisions that are probably far-reaching, provisions that will require more institutions, more activities, more instruments to be put in place in order for those provisions to come alive. And that is why you find that there are some provisions, however, that can be activated without more. But you also have a fair amount of provisions that require subsidiary rules in order for them to come into operation.
I am personally disappointed at the way the Administration of Criminal Justice Act is being run. It doesn't seem to be as magical as we thought it was when it was being put together. And that is why the new strategies that are also presented in this function also serves us well, because we are supposed to be monitoring the implementation of the Administration of Criminal Justice Act and improving on its dispensation. It does seem to me that for every law, the Nigerian wants to take a personal benefit, even if the law does not allow him to. We all want to enjoy, we all want to use the law only to fester our own nests, not to achieve justice per se. Nobody wants to be on the receiving side of the law. So he twists it, he bends it, and some of the legal practitioners who think that they are doing their clients a service also bend the law, and they go foul of the provisions of the Administration of Criminal Justice Act. But it's not just about the implementation by lawyers and the courts. There are also some provisions that are supposed to be instituted by the government itself. For instance, the database. We are supposed to have a database by now. Those are the areas where I think that we have fallen short, and I think Nigerians must rise up. Government and individuals must rise up in that area.
Let me say this boldly to lawyers that are here who come to court, either as prosecutors or defense counsel. Don't come to the FCT High Court thinking you will come and ask any judge to listen to your preliminary objection, either against the charge or anything related thereto, on the ground that your client is not linked with the charge and that he is not even get into the dock for cognizance of the charge. No judge in the FCT will accede to your request, because I have discussed that with them and we have taken a position, because at that time the court is not having dominion over the charge, and you want him to take your application, discuss a charge that is not before the court. How can that be in law and logic? The charge is not before the court. The judge has not seized dominion over the charge. You want him to listen to your application, challenging the charge itself. How can that be? Besides, in the spirit of the Act, speed up disposal of cases. Interlocutory issues will be deferred till at the end of the hearing of the substantive matter. It makes a lot of sense. If you are saying there is no connectivity, by the time witnesses are taken, the court will be in a better place to understand if there is any nexus between the charge and your client. These and many other things we have taken position. So if you are come to the FCT High Court, please brace up. And finally, I am setting up 3 panels of judges, 3 each, to deflate all the existing heavy dockets before the judges. Sequent to that, practice direction will soon be enthroned, where crystally clear everybody will see, in exercise of my constitutional powers, I have handed down a practice direction that enables settling of the panel, so that we clear all these old cases to pave way for speed of trial in cases that will come later.
This is the reason why, after fighting so hard for the passage, the Center for Socio-Legal Studies has taken on the next logical task of promoting the understanding of the Act's provision and their effective implementation.
What we are trying to do is to help to simplify the Administration of Criminal Justice Act so that the objectives of the Act can be better realized, so that it will not just be a mere law on the pages of the books, but it will be put into practice. It will be put into practice across the country for effective justice administration. Many things have happened. The Administration of Criminal Justice Monitoring Committee has been set up by the Chief Judge of the FCT. The panel, Chief Judge of the FCT has already put in place practice directions that will guide the implementation of the Act. The strategy document is being developed. Many courts, in fact, the Supreme Court has given a very commendable judgment, saying that there can no longer be interlocutory, there can no longer be stay of proceedings because of interlocutory applications, which led to the delay of so many cases in the past. So in the last 1 year, a lot has been done. But much more could have been done if we had better knowledge, if people who are supposed to implement this law, judges, prosecutors, investigators, had better knowledge of the law itself. So we need to build more capacity. We need to create more awareness. We need to sensitize the public. We need to inform the law enforcement agencies, especially even those who are not lawyers. They also have a part to play. So it is by so doing that the law will be internalized. Then it will be institutionalized, and then we will reap the benefit of the law.
Commendable work has been done in the documents. What it does actually is identify areas that need to be developed and need to be built upon in order to make the provisions of the Act workable. It is, if you like, you can call it putting flesh on the skeletal frame of the SCJ. For example, when you look at the SCJA provisions on non-custodial penalties, and you look at something, for instance, like community service or probation, these are provisions that require additional guidance, additional instruments. They need you to empower probation officers. They need you to appoint and designate community service officers. And you also need to have rules by which these officers can operate. I see this strategy, which has captured most of these rules behind the law, as it were, as very important, and it should be a very good instrument to guide the implementation of these acts.
But it is not all complaints. Recognitions must be given to those who in the first place worked for the existence of the Act, which is what the Center did. To further promote the proper usage of the Act, some Nigerians who had been instrumental to the passage of the Act were honored. They include Vice President Yemi Osinbajo, whose initiative as Attorney General of Lagos State gave a path into what the Act should look like. Former Attorney General of the Federation and Minister of Justice, Akin Olujimi, his successor, Chief Bayo Ojo, former Senate President David Mark, Senator Umaru Dahiru, Dr. Ali Ahmad, present Speaker Kwara State House of Assembly, but who was at that time Chairman House of Representative Committee on Judiciary, Femi Okewo of NTA, who organizers said championed the cause of public awareness on the Act, and many more both in the legislature and executive arms of government.
Well, I'm happy that, you see, I've been recognized for the little thing I was able to do when I was privileged to serve this great country of ours. Nobody knew that this would come today, but I know that without you see, the efforts and the cooperation of those who worked with me, I probably would have not been able to achieve what I achieved. So I'm happy that today we have people who are saying, oh, we appreciate what you did. You laid the foundation, and the others were able to carry it to a conclusion.
The Administration of Criminal Justice Act is a very important act for Nigeria. Every Nigerian has complained about the slow pace of justice dispensation. Every Nigerian knows that our courts are not ideally equipped. Every Nigerian also accepts that the justice system does not seem to guarantee enough justice for either the victim or for the criminal or the suspect. And so when the idea of rejuvenating and strengthening our criminal justice administration system came on, it was only natural that the media would feel that this is part of their duty. And that was what I felt all the while. I just had a particular personal attachment to this act, or the bill as it was then, and so I found it duty bound on my side to continue to pursue it. And I pursued it with all the vigor and interest that I could muster. Today, that is being recognized. But I want to say that NTA provided that platform. And just like it was said there, I'm just like a face of the media, the face of the people who have tried to continue to encourage Nigerians to do something about changing their administration of criminal justice system. Thank God that we have it here now.
The draft strategy is expected to be forwarded to the monitoring committee of the Act.
What is next from here is that this draft strategy document will now be subjected to serious workshop at which representatives of the various agencies will participate. And then a final document will be prepared. That final draft will be published and distributed to police stations, courts, court registrars. We'll continue to consult with them to show them that this should be done, this ought to be done. This committee, Administration of Criminal Justice Committee, ought to meet at least once per quarter. Have they met? If they have not met, why have they not met? You know, we will subject this document we will hold consultations with the agencies around the provisions of this document. I believe that in the process, there will be better awareness of the provisions and then better awareness of their roles in implementing the law. That is what we plan to do next. You know, we continue, with every passing day, we continue to improve our understanding of the law. And then we disseminate information, we conduct sensitization, and there will be better awareness about the law.
A very, very important look at the Administration of Criminal Justice Act and the suggestions that are being brought in to see if government in the implementation of that act can incorporate these new areas, and then, of course, the attempt to say thank you to those who played very vital roles in making that law to come into being. Thank you for being part of the scale today. More issues are always coming up in the society, and the scale will not miss out on them, particularly when it concerns the judiciary, the justice system, and our law. We'll see you again.
NTA language.
Jama'a masu kallon labaran NTA Hausa barkanmu da warhaka. Ni ne
Ekukale lo de yin wise kudede.
Igbo murum kachano.
Broadcasting in the language you understand better. Our programs. Transmitting on the Star Times platform 24 hours.
Àwọn onímọ̀ nípa ètò ẹ̀kọ́ lórílẹ̀‐èdè Nàìjíríà.
Hukumar tara kudaden haraji ta ƙasa.
Alanya na ọchịchị mba United Arab Emirates UAE.
The only channel that speaks your language.
Anyị ga-eweta akụkọ gbasara ọrịa ahụ nke wakporo obodo anyị.
Kálejì, mo kọ́kùnrin, mo kóbìnrin, mo kí ọmọdé, mo sì kí àgbàlagbà.
Mu kokari mu sauke nauyin alƙawarin da muka ɗauka.
Ẹ kú lẹ́yìn tèmi, ẹ káàbọ̀ sórí ètò wa ètò yín ètò obìnrin tó dángájá.
Wa ya fi cancanta a ɗauka a matsayin ɗan aikin cikin gida.
Jama'a
masu kallon tashar NTA Hausa barkamu da warhaka.
Kí ni ayẹyẹ ọdún iléyá tá máa ń ṣe lọ́dọọdún yìí rọ̀ mọ́?
NTA, you can't beat the rich.
Music of my childhood was completely British and American.
So my signature tune is pretty much
Robbers they rob, they no see you, brother.
And like you said, I'm robbers rob, they no see you. They don't see me, my brother. It happened to me.
Many months and many years and come and go.
Baba God, we say thank you.
The music is the way that the whole world can connect.
Sometimes music goes with comedy. I love music.
Let the love for music keep burning in you.
Music and art, a must watch.
Imagine a station where you access information. Think of a station that creates awareness for national development. Imagine a station that prepares you for a bright and greater future. A station for all ages. Documentaries, classroom and television, events coverage, children's programs and variety shows. Always stay tuned to NTA Knowledge on the Star Times platform, channel 359. For partnership, sponsorship and advert placements, contact us on NTA Knowledge. NTA Knowledge, learning to broaden horizon.
Our programs are getting better and fresher. And it's because we are thinking about you. NTA, it's all about you.
This is the network service of the NTA.
Hello, thanks for joining us on this week's edition of You and Your Reps. I am Omotola Omojola. Nigerian workers may be in for a good time soon as the Green Chamber is working at ensuring that not only are wages worth the while, but also ensure that periodic reviews of salaries are done to meet economic realities. The House passed for second reading a bill to amend the National Minimum Wage Act, which provides for mandatory periodic review of the national minimum wage every 5 years.
The Constitution, while providing for the review of pensions every 5 years, there is no law that provides for the review of wages. Mr. Speaker, honorable colleagues, what this bill seeks to do is to actually codify and to make it mandatory for the review of workers' salary every 5 years. There's no gainsay that 18,000 is not a livable wage. It's not. No matter which way you want to look at it. You don't have to be benevolent to understand that nobody can survive on 18,000 a year. The cost of transportation to and from work already gobs that 18,000 in a month. Mr. Speaker, honorable colleagues, it is important that we understand, we realize there are perhaps even unintended consequences, resultant consequences such as crimes, kidnapping, corruption. We cannot argue and say we want to stamp out corruption and not give people the livable wage they need to put bread and butter on the table for their families.
The very first section or subsection that we should be dealing with should be this section that gives out this ridiculous amount. This is a law that came into effect as far back as 1981. So we're talking about 2017. So it is critically important that we do not take this as an oversight and leave this to continue because it's ridiculous.
In support of the bill, I want to say that there is nothing inimical in a review being done in 2017, and by 2018 June, we found the economic situation in the country warranting another review. So we can review as many times as possible. But a situation where a government will not care about when the review was done last, this is to compel such government to review this minimum wage.
When I took my study on corruption indices in the civil service, I found out that it's at the level of retirement that people tend to become corrupt. And it's simple, because they know that when they retire, they don't have house, they can't take care of their children, they don't have anything, because what they are paying them is so small that they can't even make 7.
We have a minimum wage of 18,000 naira that workers can barely live on. They cannot feed their families, they cannot pay rent, they cannot pay school fees, they cannot pay health care, they cannot do anything with that. So it is important, Mr. Speaker, that the minimum wage is reviewed from time to time.
We must be ruled by law, not by men. So this chaotic situation where usually when workers ask for wage increases, they could do so in 1 year, in 2 years, or in 3 years. But when we have a law that guides all this, I believe that it will be in a position to guide our business relations and our public service relations with the labor.
You cannot expect a worker to be on the same salary level for 5 years, given the present economic vagaries in the country. And so, if they are sure that there's going to be a review, at least their minds will be at rest. We cannot afford economic shutdown every time workers are agitating for a review.
You see, my fear is this. If you look at our Constitution, Section 162, subsection 2, which empowers the President to lay before the House review in revenue allocation to federal, state, and local government, there has not been any respect, no regard for it. So what gives us the impression that when we do this review, and for the review, that there will be respect for it.
The Green Chamber also celebrated Nigeria's democracy, the efforts of the founding fathers of a nation and the heroes of Nigeria's democracy. It was also a time to bring to the consciousness of all the strength of the unity of a nation like Nigeria.
Because of these challenges, we've had a lot of agitations. Of course, a lot of them are genuine, but a lot of them are born out of the frustrations that people have, maybe because of the challenges. Questioning Nigeria's unity because of our problems, I think should be off the cards. Looking for ways to try to take our country forward is what all of us in this house should look forward up to. And so, as we today celebrate Nigeria's unity on the floor of these hallowed chambers, I think everybody should put on their thinking cap to bring ways, as we've always been doing on the floor of this house, to try to make Nigeria a better country, both economically, both in terms of socially, industrially, and all of that.
I would equally want to acknowledge our democracy heroes, the late Chiwobwe Awolowo in the First Republic, the late Mala Amini Kano, the late Sedona of Sokoto, and the Duke of Africa. Equally in the present dispensation, we have to acknowledge the effort of Chief Dr. Olusegun Obasanjo, late President Yar'Adua, and President Goodluck Jonathan for making democracy to flourish. We must acknowledge what he did in 2015 that has made this democracy sustain. For that, Nigerians are really grateful to him. Equally, I'll have to give it to my mentor, President Muhammadu Buhari, for ensuring, for working hard to sustain the democracy by fighting corruption.
We, as the leaders of this democracy, we as the people who are the drivers of this democracy, insist that the executive arm of government drives a democracy where the truest words of democracy, like liberty, freedom, equality, lack of discrimination, constitutionalism, fairness, liberty, the ability to grow, with a free press and a strong civil society. Only then, Mr. Speaker, sir, can we as a people say that our democracy is actually growing.
I think it is important that we appreciate the fact that democracy will only thrive where there is respect for the rule of law. Where there is no respect for the rule of law, you may end up having autocracy or dictatorship. And my sincere advice is to commend even the government, and I will do that, in line with the issue of what they are doing in fighting insurgency. It has been a very wonderful step with all the challenges.
It is important at this point that we appeal to those who may be calling for the breakup of this country. Appeal. Perhaps it is time for all of us to sit down on a round table and fashion out a way forward how we want to coexist, so that next year, May 29, we will be celebrating Democracy Day.
In our party system, we have discovered over a very long time that we have to compromise before you take steps. In our political environment, we just have to find a way of compromising things, not the quality now, not the quality of service, like the leader has just said. We have to compromise by making sure that we live together as an indivisible entity, because people quickly forget that one of the strengths of a nation is in the population. When you have the required population, definitely you are likely to have a very big economy.
We must recognize the struggle, the sacrifice that was made by the heroes of June 12, people that went on exile, people that lost their lives in the course of the realization of June 12, so that military adventurism will be consigned to the dustbin of history, must be recognized as we celebrate democracy in Nigeria today.
To ensure that Nigeria attains the 2030 target for African countries to attain the Sustainable Development Goals, the House of Representatives passed for second reading a bill seeking to provide for the establishment of a Sustainable Development Fund.
Currently, we have an office in the presidency which is on NDG. In fact, it's a policy initiation which, under democracy, we should not be having it, because we are under democracy, and such office, which we are always budgeting for, must have the support of the legislation from this chamber and also from the Senate. So, Mr. Speaker, that's why we have to legislate and domesticate the Sustainable Development Fund, so as we should be doing things right under democracy. Mr. Speaker, we have a lot to gain from this. We will develop our people as other countries, even less endowed than us, have done.
This is one policy that has really brought development to the grassroots, Mr. Speaker. Mr. Speaker, in the last few years that I've been in this House, the SGD has really helped to bring empowerment items even to the smallest of my constituents. Mr. Speaker, but I must say that they have not succeeded 100% for the very simple reason that they lack funding.
The Sustainable Development Goals are all the objectives of governance, which the national budget, the annual national budget, is all about. When we take the duties and functions of all the ministries, each one of them is to take one aspect or the other of the Sustainable Development Goals.
What this bill seeks to do is to give legal backing to some of this responsibility. And he did say, if you look at the narrative he gave us, that the intention of the bill is to have a time frame where this will expire. He said 15 years.
Also passed for second reading is a bill on the need to establish the Federal Capital Territory Metropolitan Management Council.
This bill seeks to give a legal backing, a legal framework to already existing council. It talks about the Federal Capital Territory Metropolitan Management Council. Metropolitan Management Council. Mr. Speaker, all year round, we budget for this very council. So it's not an issue of a new council that will be funded. Funds are already being provided for them. If we provide funds for them with no legislative backing, then we may be erring also. For us to satisfy our own legislative duties, we must provide them with the legal framework, the tenure of office, and all what they do. Just like we've also provided to the local government administration and all whatnot. Before now, they had no legal backing, they had no tenure, they had no regime.
It's an urban management outfit that manages the beautification, the livelihood, the liveliness of the city. It ensures that flowers are planted when they are supposed to be planted. It ensures that development control activities are done properly so that people do not just begin to build kiosks and houses where they're not supposed to be. It ensures that green areas are kept green. It ensures that waterways are protected and given proper facelift. It ensures that the city is beautiful. This bill is important, and I urge that members support it so that we can give force of law to this beautiful idea. Way back, you could see a city, the neatness.
You have this infrastructure, you find that laws are obeyed in terms of traffic, neatness, and so on. And this is what we go out in so many countries to see. So it is important that we support this bill. It is important because it will upgrade our city and make it a world class.
You cannot manage a city without proper funding.
Order.
It costs billions, it costs the government billions of naira for this kind of cities to be adequately managed. So this bill is really timely. With it, the Management Council can be adequately supported, and our city will definitely look good, and all of us will be proud of it.
Still on the FCT, our committees of the House segment today features Chairman House Committee on FCT Area Councils and Ancillary Matters, Representative Beatrice Zephaniah Gisalo. The lawmaker speaks on the various oversight efforts of the committee to ensure that other area councils come up to the level of the municipal in terms of infrastructure.
By the grace of God, I chair Committee on FCT Area Council and Ancillary Matters. I oversee the activities of the 6th Area Council, including some departments in the FCT like Social Development Agency, Department of Agriculture in the FCT, the NYC of the FCT, Department of Area Council and Service Commission, Department of Area Council Secretariat, and then Department of Satellite Town, Department of Satellite Town Development Agency, and Department of Resettlement and Compensation. Abuja have 6 area council as a satellite town, and then there's a department called Satellite Town Development Agency.
This is the network service of the NTA. We now join our outside broadcast crew for a live telecast. Please stay tuned.
As customary, we take the national anthem of Nigeria.
Please be seated. Your Excellency, the Acting President, Professor Yemi Osinbajo, SAN, the Honorable Minister of Justice, Abubakar Malami, SAN, the Honorable Minister of Foreign Affairs, Geoffrey Onyema, the Honorable Minister of Finance, Kemi Adeosun.
And welcome to the conference on promoting international cooperation in combating illicit financial flows and enhancing asset recovery to foster sustainable development. The 3-day event, which is holding at the State Banquet Hall, is expected to run between today and Wednesday. And the acting president, Professor Yemi Osinbajo, is the special guest of honor at this event. The event is an initiative aimed at mobilizing policymakers and experts in finance, as well as other relevant fields, to ensure that recovered assets from corruption,
distinguished ladies and gentlemen, it gives me great pleasure to welcome you to this auspicious occasion. My name is Bolaji Owasanwoye. I'm a member of the Presidential Advisory Committee Against Corruption and the Executive Secretary. I'll be anchoring this program with two colleagues, Akinremi Bolaji, who is the Minister Plenipotentiary and spokesperson for Nigeria's permanent mission at the UN, and my colleague, Mrs. Stella Anokam, who is Director of International and Comparative Law at the Ministry of Justice. This is a great occasion, it's a great day, it's momentous. It's an international conference convened by Nigeria to make her voice heard, to create a platform for a conversation to discuss two critical things that are very important to this government and its people. How to stop the bleeding and the hemorrhaging from illicit financial flows, how to improve on this framework for asset recovery and asset return. Hitherto, the world, and rightly so, had focused very much on a lot of looting that had been done by the public sector and politically exposed persons. And the conversation about recovery and returning that goes on well. But when it comes to the point of returning the assets seamlessly, efficiently, and timeously, the conversation drags. We need to negotiate and discuss our way out of that situation. Secondly, we recognize that the looting of the public patrimony by politically exposed persons is a virus that must be dealt with. But that accounts for about 30% of what leaves developing countries to developed countries. About 70% goes out through transactions by the private sector. And that was why the African Union set up the high-level panel chaired by former President of South Africa, Thabo Mbeki, which came up with very significant and commendable recommendations. This conversation is to break the ice and to have Africa, led by Nigeria, to begin to take steps to stop the bleeding through those transactions. Therefore, it gives me great pleasure to welcome all of you to this meeting. If you look at the program, you find there is structure to it, a schematic. That structure leads us to a conclusion, to a conversation about international cooperation, and then an outcome document. I'm happy to recognize the input of the government of Norway in the conversations that are taking place before today. So without much ado, I will invite the president, the chairman of the Presidential Advisory Committee Against Corruption, a man who needs little or no introduction because you hear him very often on the newspapers. Please join me in welcoming Professor Ishejua Sage, SAN.
The Acting President, the Attorney General of the Federation, ministers here present, the keynote speaker, our international visitors, distinguished ladies and gentlemen. Financial hemorrhaging occurring in any society or country is a grave phenomenon. Basically, it deprives that society of the capacity to meet its social and economic responsibilities and targets. When that society is an underdeveloped one, as is the case of third world countries like ours, mainly in Africa, the Caribbean, and some parts of Asia, we will have a human tragedy of grave proportions unfolding in our hands. Let's take Nigeria as an example. In a study done by Professor Bolaji Owasanwoye, the Executive Secretary of PACAC, in 2014, he found that between 2006 and 2013, 55 top public officers, private businessmen, illicitly diverted a total of 1.35 trillion naira, roughly at that time, $7.05 billion to themselves at the expense of the ordinary Nigerian citizens. This was what was revealed. What was not revealed or recorded turned out to be far more mind-boggling. These include trillions plundered in fuel subsidy scams, the 2.1 billion Dasuki Gate scam, the hundreds of millions of dollars taken from the NNPC by Mrs. Desiani Madweke to bribe election officials in 2016, and the list goes on. In a press release by the federal government published on the 19th of January 2016 on the negative social impact of the looting of national assets, the government provided the following insights. And I quote that release. 1/3 of stolen funds could have provided 1/3 of that amount could have provided 635.18 kilometers of roads, 36 ultra-modern hospitals. Truth. You give our elites an opportunity to do a project, and you vote money for that project, the first thing these tiny Nigerian elites do is to divide that money amongst themselves. You take this, you take that, you take this. This little one that's left, let's devote it to the project. That project is never completed. Nigeria has the largest number of uncompleted projects in this world. Many people just take the money and walk away in collusion with the ministry or agency that awarded the contract. If I appear to be drifting of the subject matter of this gathering, let me now draw the connection between the two. That is between unrestrained looting and illicit financial flows. Most of the financial assets pillaged from state coffers find their way out of the country as part of the illicit financial flows. The immediate impact is that Nigeria is deprived of the capacity to realize its sustainable development goals, particularly that of the UN, officially known as Transforming Our World. These goals include 1, no poverty, that is eradication of poverty, 0 hunger, eradication of hunger, good health and well-being, quality education, clean water and sanitation, affordable clean energy. These are some of those goals. How on earth is any society to achieve that when it has bled off virtually 90% of its resources? And what is more, this hemorrhaging is leaving our shores, our underdeveloped shores, for those of the economically developed world, developing them more whilst we are retarding into the Stone Age. The concept note of this conference informs us that the annual flow of proceeds of criminal activity is estimated at between $1 billion and $1 trillion and $1.6 trillion, the annual flow. And half of these flows come from developing and transitional economies like ours. It is therefore vital that as a country and Africa as a continent improve our capacity in understanding and stemming the illicit financial flows, this hemorrhaging. If we are to have a chance to meet our sustainable development goals, or if we are ever to dream of transformation from third world to something better, even by 2030, we have to acquire the capacity to stop the flows. The importance of this subject matter and its indispensability to a tolerable future in developing economies like Nigeria is confirmed by the caliber of participants at this conference. The acting president is here, the UNODC is here, ECOWAS is here, Global Witness is here, and Reconnect is here. Organizations, Global Impact New York is also here, and many other relevant international organizations are here, including the cream of international experts and consultants who are leaders in this field. Therefore, we are very, very privileged indeed and lucky to have you here. I know that the battle against illicit financial flows in Nigeria will not be the same again after this conference. Thank you very much for coming, and you are most welcome.
Thank you very much, Professor Sage. Can we please give him another round of applause? Indeed, the bleeding must stop.
The Chairman, Presidential Advisory Committee Against Corruption in Nigeria, PACAC. The event, which is holding at the State Banquet Hall here in Abuja, is a 3-day event running from today till Wednesday. And the event is an initiative aimed at mobilizing policymakers and experts in finance, as well as other relevant fields, to ensure that recovered assets from corruption and illicit means are channeled towards meeting the Sustainable Development Goals.
Your Excellency, the Acting President of the Federal Republic of Nigeria, Professor Yemi Osinbajo, Senior Advocate of Nigeria, the Honorable Minister of Foreign Affairs, Geoffrey Onyema, the Honorable Minister of Finance, Kemi Adeosun, the keynote speaker, Akere Muna, the Accountant General of the Federation, Alhaji Ahmed Idris, Comptroller General of Custom, Colonel Hamid Ali, the Governor of the Central Bank of Nigeria, Godwin Emefiele, the Chairman, Federal Inland Revenue Service, Dr. Fowler, the Chairman, Presidential Advisory Committee Against Corruption, Professor Ise Sage, the Chairman of the session in the person of Mala Nuhu Ribado, the former Chairman of the Economic and Financial Crimes Commission, my Lords, the Justices of the Supreme Court, Court of Appeal, and indeed the Federal High Court here in present, members of the Diplomatic Corps, ladies and gentlemen, good morning. It is with great pleasure I welcome you all to our nation's capital and to the first international conference on promoting international cooperation on combating international financial flows and enhancing asset recovery to foster use of return assets to victim countries for sustainable development, and in so doing, ensuring sanctions for perpetrators of acts of corruption. The government in Nigeria, under the stewardship of Muhammadu Buhari acknowledges the legal system as an important element in its strategy to address the problems of corruption in all its ramified manifestations, including the adoption of effective preventive measures against corruption, recovery of stolen assets, and putting mechanisms, systems, and processes in place to profitably manage stolen and recovered assets. Just recently, the Senate passed an executive bill on the mutual legal assistance in criminal matters between Nigeria and other foreign countries to facilitate identification, tracing, freezing, restraining, recovery, forfeiture, and confiscation of proceeds, property, and other instrumentalities of crime. This is a welcome development. Also, on the 27th day of April 2017, stakeholders in Nigeria validated and adopted a national anti-corruption strategy, and it is awaiting the approval of the Federal Executive Council. These are clear manifestations of political will and legislative steps aimed at reinforcing the strategy of addressing the problems of corruption that calls for international support through aggressive action of repatriation of illicit wealth. It is in that direction that the Nigeria calls for international support. Nigeria has signed agreements and MOUs with various countries in a bid to encourage international cooperation, and a lot of efforts has been exerted to develop logistics to aid and facilitate swift sharing and exchange of information. This, in turn, will aid the investigation, tracking, stopping, and return of stolen assets. Furthermore, the initiation of the ongoing review of the Nigeria Financial Intelligence Agency Establishment Bill and the Proceeds of Crime Bill will aid in tackling illicit flows. The commitment to prosecute corrupt public officials and the recovered looted public funds is reflected at all levels and sectors where corrupt practices occur. I hope in the course of this conference, the return of stolen assets to victim countries will be facilitated and the buy-in of the international community through repatriation of the looted funds of Nigeria will be adequately addressed.
Attorney General and Minister of Justice, Abubakar Malami, the Honorable Minister of Finance, Kemi Adeosun, members of the Diplomatic Corps, distinguished members of the High Table, distinguished resource persons, representatives of civil society organizations, ladies and gentlemen. It's a great honor to be here before you all today to discuss a very, very important topic for our country. The hosting of this international conference on combating illicit financial flows and strengthening of asset recovery to foster sustainable development attests to Nigeria's conviction that the global challenge of illicit financial flows deserves global solutions. This is pivotal to the implementation of international agreed development goals, particularly the Addis Ababa Action Agenda of the Third International Conference on Financing for Development and the 2030 Agenda for Sustainable Development. The interlinkages between corruption and underdevelopment, particularly in Africa, cannot, I repeat, cannot be overemphasized. the report of the high-level panel on illicit financial flows from Africa, commissioned by the Africa Union and the United Nations Economic Commission for Africa, indicate that Africa loses twice as much in illicit financial flows through tax evasion and trade and service mispricing by multinational corporations. The magnitude of the loss of funds through illicit financial flows actually exceed what Africa receives in financial aid and is a key factor responsible for the underdevelopment of the continent. It is also a contributory factor to the recurrent challenges of mass migration and indeed terrorism that we are all experiencing on this continent. Furthermore, illicit financial assets harbored abroad also deprive developing countries of resources required to progressively realize the right to development. For us in Nigeria, the fight against corruption and illicit financial flows is a shared responsibility and must be tackled by the global community. More specifically, we urge that concerted efforts must be directed at curbing illicit financial flows in order to generate the much-needed finance for Africa's development. Our commitment in this regard was demonstrated at the 71st United Nations General Assembly, where we co-sponsored two crucial resolutions to refocus global attention to the menace of illicit financial flows and the need to strengthen mechanisms for asset recovery. We therefore view this conference as very much a step in the right direction of internationally agreed positions to stop, track, and recover illicit financial flows. Most importantly, Nigeria believes that there is a need for the global community to urgently redouble efforts to substantially tackle illicit financial flows through strengthened national regulation and increased international cooperation. In addition, we urge that concerted efforts must be directed at the enhancement of disclosure practices and transparency in both source and destination countries, including by seeking to ensure transparency in all financial transactions between governments and companies to relevant tax authorities. In line with the thrust of the United Nations General Assembly Resolution A/71/208, we urge global institutions, including the International Monetary Fund, the World Bank, and the United Nations itself, to assist both source and destination countries in the implementation of effective measures aimed at detecting, preventing, and countering corruption. Similar international support must be extended to the identification, freezing, or seizure of asset derived from corruption. The United Nations, in particular, must continue to facilitate robust global dialogue on the ills of illicit financial flows and the need for collective action. We urge the international community to strive to eliminate safe havens that create incentives for foreign transfer of stolen assets and illicit financial flows. Nigeria further urges the international community to support developing countries' efforts to curb and counter illicit financial flows, which are very seriously straining Africa's capacity and the resources required for the implementation of the 2030 Agenda for Sustainable Development. Moreover, we urge destination countries to remove bottlenecks and conditionalities hindering the recovery of illicit acquired funds and assets. We know this from very sad experience as we seek to have restitution of funds that have been deposited in many foreign countries. The enormous cost to try and access those funds and the unacceptable delays in accessing those funds are things that have to be given very serious attention to by the United Nations and indeed the global community. With the crop of distinguished panelists and experts invited, I am confident that this conference would further strengthen global efforts at nipping the monumental challenge of illicit financial flows and asset recovery in the bud. We shall continue to partner and collaborate with like-minded countries to address the negative impact of the non-reparation and restitution of illicit assets to countries of origin. I wish you all a very successful conference. Thank you very much.
Thank you, Minister of Foreign Affairs, for a brilliant speech. Set the tone for our conversation. There are many distinguished personalities here from Nigeria's public sector. I will not even dare attempt to acknowledge or recognize all of them. Some of them have been recognized by the Minister of Justice. We know that many distinguished ministers and heads of agencies are also represented. I just want to say thank you all for coming. This is about us. I also want to acknowledge the support for the hosting of this conference, which has been provided by MacArthur Foundation, Open Society Foundation, represented in Africa by OSIWA, and the Ford Foundation. These three foundations have been supporting the work of the Presidential Advisory Committee Against Corruption and some other government agencies in dealing with one of the key issues that President Muhammadu Buhari set out to confront, which is corruption, through the Anti-Corruption Fund that has been set up and is managed by Trust Africa. So please let's give a round of applause to those who are supporting the funding of this program. I said earlier on there is a scheme to the program, and the two ministers have called attention to some of the critical issues that are of concern to us, that we want asset recovery to be matched with asset return. It's one thing to recover, help us recover money that has been stolen to your country. It's another thing for you to return the money to us. We want the money back. But there are people who make it possible for the money to be taken away in the first place. They remain invisible. Hardly does anybody talk about them. They are the middlemen and the facilitators who make it happen. The lawyers, the accountants, the banks, the customs officers that look the other way. And those who are supposed to do what they're supposed to do and do not do it. We are pushing, when I say we, I mean the Presidential Advisory Committee Against Corruption. We're pushing very hard that when you pick up the politically exposed person and the principal actor, pick up the middleman. Let them face the music together. One of the persons who is very familiar with the subject of today in various ways, much more than I can describe or explain in a short introduction, is Barrister Akere Mona. Formerly Vice Chair of Transparency International, currently Chair of the International Anti-Corruption Conference Council, which held a very, very successful, notable conference last December in Panama. He was there and I was there, I met him there. And was a member of the high-level panel on illicit financial flows, popularly called the Thabo Mbeki panel. He has all of the experience, the information that this conversation is all about. More importantly is that he's a man whose time is heavily under pressure But given his concern and interest in this subject matter, he agreed to join us as a keynote speaker, having just returned from another international engagement from somewhere in Asia. Ladies and gentlemen, please join me in welcoming Barrister Akere Mona, all the way from Cameroon, one of us, to give the keynote speech.
Your Excellency, Professor Yemi Osibanjo, Acting President of the Federal Republic of Nigeria, Distinguished Minister of Foreign Affairs, Mr. Jeffrey Onyema, Distinguished Minister of Justice, Mr. Abubakar Malami-San, Distinguished Chairperson of the PACAC, Professor Sagay San, distinguished members of government, and at this point, Mr. President, I will seek your leave and permission to adopt the exhaustive protocol that was outlined by the Minister of Justice. To which I will add my greetings to members of the media and civil society, and mostly to a very good friend of mine, Madam Nuhu Ribadu, who initiated me in the art of speaking truth to power. Well, I must start by thanking the organizers for inviting me to this country, because Nigeria holds a very special place in my heart. I was born in Nigeria. I was born in Enugu 65 years ago, when my father from Southern Cameroon was part of the government of the Eastern region. As a matter of fact, I even know the hospital where I was born. I was born in Parkland Hospital. In those days, it was known as the White Man's Hospital. And when I was born, the newspapers in Enugu titled, "First Black Child Born in Parkland Hospital." So that's my claim to fame. And the last point I will make about my affinity to this country is the fact that 12 years ago, I was elected president of the Pan-African Lawyers Union. I was there for 6 years on the proposal of the Nigerian Bar Association. Then it was, I think, Bayojo who was head, and the whole engine and the works was done by Femi Falana, the mover and shaker, who is right here. In 2011, the Fourth Joint African Union Commission and the United Nations Economic Commission for Africa mandated the ECA to establish a panel, which became the high-level panel. And I should recognize my fellow panel member, Ambassador Apata, who is sitting right there. And this was done in a bid to ensure that many African countries do not fail to meet the Millennium Development Goals. So along with Raymond Baker, who might be coming later on today, and Chairman Apata, Ambassador Apata, we were able to work together. We still work together because the panel was mandated to continue by the African Union. We've been doing this under the guidance of an extraordinary gentleman, the former president of South Africa, President Thabo Mbeki. Ably assisted, of course, by a very strong technical staff of the ECA. You will listen to a slew of experts on the subject of illicit financial flows from Africa throughout this program. So I will not delve into any technicalities, intricacies, or statistics that inform this issue. I will just share with you some thoughts about the slogan that was adopted by the high-level panel, and you've heard some of it from some of the speakers. Track it, stop it, and get it. That is the slogan we adopted. A continent is losing anywhere from $50 to $80 billion annually in financial flows. And despite the inflow of development assistance, as we heard from the Minister of Foreign Affairs, Africa still remains a net creditor. Some will argue about the numbers. I think that we shouldn't make that a problem because the magnitude of this phenomenon is established. To be able to track illicit financial flows, I think it is important to know the nature of the beast. And I would invite you to go on the web and look at the panel report, and you will see the 15 recommendations that were, or findings that were made by the panel. I'll just speak to about 5 of them. Transparency is key across all aspects of illicit financial flows. New and innovative means of generating illicit financial flows are emerging. More effort is needed in asset recovery and repatriation. Weak national and regional capacities impede efforts to curb illicit financial flows. Financial security jurisdictions must come under closer scrutiny. A key factor in being able to track financial flows is identifying the actual owners. And that is one of the issues, of course, that was raised in the findings I just read out to you. And the culprits here are the financial secrecy jurisdictions. One main reason why secrecy in financial system exists is to afford the rich and powerful tax planning opportunities. Once again, on our continent, a system that was put in place to ease business processes has been hijacked by greed and self-interests. It is imperative that we make it a priority to double efforts to end the use of financial secrecy for corruption, drug smuggling, money laundering, terrorism, people trafficking, and other illicit financial practices. Also imperative for tracking illicit financial flows is the implementation of existing commitments. And there's no shortage of this. I think on the continent we are very used to signing agreements, making commissions, and believing that after you do that, the problem is solved. Wrong. These agreements establish a roadmap. The solution comes from the effective follow-up of these commitments. And I think this conference is key because it might come up with a roadmap on implementation. As you know very well, the African Union declared 2018 the year of the fight against corruption. And I'm sure with pleasure that the president of your country will report to his peers about the pioneering example that Nigeria can bring to the rest of the continent. Multiple commitments have been made at the G20, G7, OECD, and others. For example, at the London Anti-Corruption Summit in 2016, 43 countries made 600 commitments to tackle corruption. The largest thematic area related to beneficial ownership information. 36 countries made a total of 100 commitments. Transparency International has tried to monitor the implementation of these commitments, which are very crucial in ensuring any follow-up. TI chapters, including UK, Ghana, Nigeria, of course, Kenya, are tracking the implementation of beneficial ownership commitments. But at a global level, the difficulties still remain, especially in the area of beneficial ownership, which is key to locating exactly where this money is parked. In the TI report of 2015, we're able to show that 16 out of 20 G20 members had weak or average beneficial ownership frameworks. And even by the standards of the countries themselves, they fell short. As regards foreign bribery, the 2015 report on foreign bribery, the 41 OECD convention countries don't even perform to the point of being termed as being effective. Money laundering. The Financial Task Force on Money Laundering have been they have been in place since 1990. However, for the first time in its current evaluation round, which is the fourth actually, it is looking at the effectiveness of countries' policies to stop money laundering. And no country out of the 30 assessed since 2014 scores the effective mark. So there's a lot to be done. Even the access to data is a problem because of the cost it can engender. It was the TI branch in the European Union tried out and discovered that if you want to access the information in the Dutch registers, you will need to spend 75,000 euros, and that is very, very high. So even on country-by-country reporting, which is what people wish for, in late May 2017, the European Parliament ventured a vote, but had to stop because of disagreements over the extent of information to be made available. So in summary, for illicit financial flows to be tracked, we need to know how they move. To recuperate them, we need to know where these flows are packed. The final prong of the slogan, that's the get it phase, is made difficult by the many of the aforementioned hurdles. If we do not know where the beneficial owners are in business transactions, it is very difficult for the funds to be reclaimed. It is now that TI is finding out in its own research. We published something in March 2017, and we looked at 10 key anti-money laundering measures, and we looked at the real estate area. As you know very well that real estate is becoming a very, very important area where these ill-gotten monies are parked. The US, Australia, and Canada have shown a lot of deficiencies in this area. In 2016, TI found that in Canada, 100 of the priciest homes in Vancouver, out of 100, 46 were owned through offshore shell companies. In 2017, March, TI found out that in the UK, or in London alone, 4 out of 10 homes have been sold to investors from high corruption risk countries, or those hiding behind anonymous companies. I don't have the figures for Nigeria, so please, I can't give you that. In April 2017, TI Brazil also found out that 2.7 billion worth of property, again, was in the name of offshore companies. So it is clear that the role of offshore companies and the anonymity that they provide is key in being able to trace the funds. Well, when it comes to one country, I don't know about Nigeria, but in many countries in Africa, we are having a new breed of farmers. People with no connection to the soil have suddenly mutated into huge, large-scale farming for the simple reason that farming in Africa is capital intensive and you pay the guys in cash. And you harvest your products and you export it. And you get money which you can account for. I suppose this is one way to harvest the fruits of corruption and create a green economy. Another thing that bothers me is what happens to frozen assets. When the money is frozen in these banks, what happens to it? I mean, senior advocates here, and they know that the person who steals is called stolen assets. That's the World Bank. It calls it in the Star report. It calls the money stolen assets. So if there's a thief at one end, the guy who is keeping the money is a handler. And in many cases, many countries, handlers have been punished more severely than the thieves. And in this discussion so far, the handlers are the banks. And we don't tend to hear too much about them. I think we need to look at the role of the banks in this issue. Should they keep the money? I think it's morally wrong that for the 8, 9, 10 years that the parties are worrying about this money should stay with the banks. It is not proper. We should look for a system where there's an escrow account, maybe in the development banks. So when the money is frozen, it moves from those banks to an escrow account and stays there till the court decides whose money it is. There is no way the person who was complicit, who even solicited the funds, can turn around and say, well, I'll keep the money till you say. And I know that there's been this discussion about the fact that when the money is going back, you have to show that they will not be embezzled again. I think that's rather preposterous. These guys help steal the money, and suddenly they feel that they should dictate the conditions under which the money goes back. It's morally wrong. I don't subscribe to that. And they even got some African civil society groups to start saying, well, we have to know where the money is going. Money should not be stolen, whether it's recovered or it's in the government offers. That's all. It's not because it's coming back that it has a different status. I agree that for budgeting concerns, you might decide that if money was stolen in the north, it goes back to the north. That's different, but that's a sovereign decision for the countries. I don't think anybody should sit out of the countries and say, well, till you tell us that you're not going to steal it again, we don't give it back. They stole it in the first place. So I hope the acting president will be able to champion this issue of the governance of frozen assets. Do they pay interest? What happens to the money when it is there for 9, 10 years? We need to have a system that when the money is frozen, it leaves the handlers and goes to a third person. And you would find that when it moves from the handlers, the recovery will be easier, because all the hurdles we have in recovery is because they want to keep the money longer. It's not because they get looking at the law. They want to keep it longer, but when it moves to a third party, and I'm presenting the development banks, you will suddenly find that recovery is easier. And you know what? If Nigeria has, I don't know, $1 billion in frozen accounts, and it's with the African Development Bank, nothing stopped Nigeria from going to the bank and say, well, listen, I need to borrow $1 billion. If at the end of the day, the money is ours, we can set off. If it is not, then we have a debt to pay back. So I think it's a win-win situation, and we've had enough of this story about, frozen assets and nothing happening to it. The thing about corruption is that our citizens tend to accept it as a way of life. And that, I think, is the most corrosive thing. It's the worst thing that corrupt individuals do to us, because our citizens accept it. Now that I've been able to prove that I'm also Nigerian, I'll tell you a story. I was going from Cameroon through Lagos to Abuja, and I was waiting for my flight at the airport in Lagos. And there were two Nigerians arguing, because I think there was a story about a governor who had been pardoned, and huge argument. One was saying corruption is too much in this country, it must stop, something must be done. And he was very vociferous and angry. And when he finished speaking, his friend looked at him and went, your money loss. was almost tempted to tell him that we money lost. We all be money lost. So, Mr. President, I do applaud you because your government has made the fight against corruption its #1 priority. The simple fact of your presence here is witness to this. It is not an easy choice. As you know, as most of all have found out, and New Ribadu knows that very well, when you fight corruption, it fights back. So, how much longer will we watch our resources depleted and the future of our children mortgaged for the sake of the greedy few? The winds of change are blowing across our continent, and they are inevitable. Our young people know better. They want better. They deserve better. They might even fight for a better tomorrow. So for those who feel that their own personal interests can always take precedence over that of their people, they should take a good look at history. Because we can certainly hide to do certain things, but it is certain that we'll never be able to hide the things we do. Thank you for having me. God bless Africa. Thank you very much. Oops.
Thank you very much, Akari Mona, for a very brilliant and reflective keynote speech. Good state. And also thank you for calling attention.
No doubt, corruption is widely known to impede development and worsen growth indicator. And that has diverted resources meant for public good to private pockets for private gain, which is a factor that has partly been responsible for current advocacy that returned assets must be brought back into the sphere of the public good, taking account of existing international commitments such as SDGs and the fundamental human rights and the needs of local citizens.
Everybody with the same brush. Usually the actions of a few tend to negatively affect all of us and the majority. You will see in your program that given the importance of the financial services sector to this conversation and given the feedback that we have, that there are concerns even therein, that people there, very important people there, want things to change, come June 30, we're having a conversation on the financial system integrity improvement. And the keynote speaker is a man who brought down a bank in England, has paid the price for it, and has become an advocate of how not to make it happen again. That conversation is going to take place June 30 here in Abuja, an initiative between PACAC, the Convention on Business Integrity, the ACCA, and the Chartered Institute of Bankers, so that we can have a conversation about how we should stop what we do not like to see and what sort of reforms government ought to be doing. So that is another date that you may have with us. It now gives me great pleasure and honor to invite our special guest of honor to declare our conference open. Now, the acting president, Professor Yemi Osinbajo, did not stumble on this conversation. Over 20 years ago, as a private practitioner, he had joined in setting up an organization known as Integrity, which focused on corruption within the private sector. And he also pioneered and pushed for players in that sector who were abhorrent and uncomfortable with what was happening to sign a pact to say we will not bribe for business. And that initiative took on a life of its own, and it is still operating and working with the private sector. So this is a subject matter that the acting president is very, very comfortable with. So ladies and gentlemen, it gives me great pleasure and honor to invite Professor Yemi Osinbajo, SAN, to give a speech and to declare this conference open. Your Excellency, sir.
Very much. Please sit. Members of the Federal Executive Council present, the chairman of the Presidential Advisory Committee Against Corruption, Professor Illicit Sage, Senior Advocate of Nigeria, the keynote speaker, Mr. Akere Muna, members of the Advisory Committee Against Corruption, heads of government agencies, the former chairman of EFCC and chairman of session, Malam Nuhu Ribadu, Your Excellencies of the Diplomatic Corps, our friends and partners who are present here, heads of government agencies, distinguished guests, ladies and gentlemen. Let me first say that it is a very special pleasure to be here and also to participate in this conference. I must say that I have participated in several conferences of this sort, but I have never participated in any where we're actually talking about recovery of stolen assets and how to cooperate on the issue of recovery of stolen assets. And I say this with a measure of nostalgia, because years ago, at a conference organized by the Transparency International in Peru, I believe it was in 1995 or so, we who came from African countries and developing countries that were intent on identifying what to do with proceeds of corruption and ensuring that proceeds of corruption were described as dirty money and as such were criminalized, and that the whole process of passing around proceeds of corruption would be criminalized. We went there with an agenda, and we thought that we'll be able to convince everyone else that the proceeds of corruption was indeed dirty money, and that banks, financial institutions, everybody alike should treat it as such. But in Peru, it just didn't fly. You know, we were heavily outnumbered in terms of those who felt that proceeds of corruption should be treated differently. At this time, many of the countries, many of the developing countries, had treaties, conventions, bilateral agreements where drug money, narcotics, proceeds of corruption, proceeds of drugs and narcotics, trafficking in drugs and narcotics, had already been described as dirty money. So you couldn't, as a bank, accept such money. That would be considered pure money laundering, and you'd be punished for it. There were all sorts of international sanctions in the conventions. But somehow, proceeds of political corruption just didn't attract the outrage that proceeds of drugs or narcotics attracted. So it took years and years and years before anyone would listen and agree that when somebody loots the resources of a country and deprives millions of people of the means by which they would even make a decent existence, that is even more criminal. That is a crime against humanity, possibly even worse than trafficking in drugs. But it's a good thing that we're here now, many, many decades after, able to talk about this, and we're joined by all of our partners and friends who also agree that this is a serious enough issue and that we should find ways of ensuring that not only are these assets criminalized properly, the transfer of these assets criminalized, but also that they are returned to their appropriate owners. I wonder how many people, I'll just talk very briefly about the whole idea that this cannot happen. The transfer of these assets up and down the place cannot happen without a handshake, if you like, between the countries where they are transferred and the institutions and countries to which they are transferred, especially the financial institutions. There is no way that it will happen without some form of connivance between international banking institutions and those who transfer these funds. So we must work at somehow delegitimizing those kinds of transactions and criminalizing them. So just as Mr. Keremuna said, so that banks and financial institutions that are engaged in this are actually called out, and they are made to face the consequences of engaging in criminal conduct. If that isn't done, then we're not likely to get very far. I don't know how many people ever heard of the story, just talking about the collaboration, or connivance, if you like, you know. I don't know whether anyone ever heard of the story of Ignatius Clean. Does anyone ever hear that story of Ignatius? Actually, it was a story told by J.K. Randall, but it became the subject of a major controversy because the same story was retold by a British author in a book, and he didn't credit J.K. Randall, so J.K. Randall went to courts and sued, and I think a settlement was eventually reached. But I'm telling this story, giving credit to J.K. Randall, so I won't be sued by him. What happened, he told the story of a certain African head of state, or no, African public official, let's not say head of state, who went to a bank, a Swiss bank. He had heard about this Swiss banker who was supposed to be, you know, in the days when Swiss banks were had secrecy laws and those kinds of things. And this particular Swiss banker was supposed to be one of the best, you know. So he went to him, you know, had a big box, went to him, and then pointed a gun at his head. He said to him, I am told that you have resources of our country, that you are keeping money belonging to my country, that you are keeping money for many corrupt people. The banker kept quiet, didn't say anything. Then Mr. Ignatius brought out a gun and pointed it at his head. He said, if you don't tell me now how many people you have been keeping money for, people from my country who you have been keeping, if you don't tell me now, I'm going to shoot you. And the banker looked down and said, I am bound by secrecy laws. I cannot tell you. I'd rather die than tell you. Then Mr. Ignatius sat down and said, you are the banker I've been looking for. I have some money for you to keep. So there must be collaboration. There must be some connivance. There must be some connivance. And it is this connivance, I think, that we should first go for. We must find the ways, and I think that a lot of the bilateral type agreements and talks that we should be engaging in, and the conventions that we should be looking forward to signing in the coming years, must be those that work hard at ensuring that financial institutions are not given a free run. Financial institutions are key to all of this, and whatever we do, we must hold financial institutions accountable. The other point I'd like to make, just to round this up, is that African countries and developing countries also must realize that it is our responsibility. It's our responsibility to ensure that we not only get this money, that we not only find where this money is, trace this money, but that we make sure that this money is returned. It's our responsibility. It's easy enough to talk about how difficult it is sometimes to get these funds, and that has already been identified. Most nations that you have to deal with are either just reluctant or don't think it's really their business, and many have civil processes anyway that make it difficult for you to return money, So, and they just simply tell you that, look, our courts are handling this matter. There's very little we can do about it. And that's really the way these things go. But I think that it's our responsibility to make it a national cause, a cause for developing countries, and to ensure that we make all of the other countries of the world have the same kind of outrage that they've had, that has been developed when they with drug money, with terrorist financing and all of that. We are the ones who must ensure that everybody is as outraged by this as we are. If we don't ensure that people are as outraged by it as we are, we're not going to get very far. No matter what we say, every country will protect its financial institutions, protect its own institutions as best as it can, and so long as it is not necessarily, suffering any major damage, they probably would not cooperate. But I think it's up to us African countries to insist and to fight at every forum to make sure that we are emphasizing this point and that we are calling out those institutions that are not cooperating and ensuring that they recognize that this, for us, is a major issue. As I keep saying, corruption for Nigeria and for countries like us is an existential problem. If we don't solve the problem of corruption, it's President Buhari who has said this repeatedly, if we don't kill corruption, corruption will kill us. That is the same for most African countries. It's the same. And when corruption finds safe havens, when corrupt money finds safe havens, it is emboldened and is able to fight back. We are experiencing in Nigeria a situation where corruption fights back and fights back so persuasively, so eloquently sometimes, and with such resources that government itself, if government is not careful, it can be overwhelmed. And it is because the resources have safe havens everywhere. There is no, if you look at the anti-corruption fight in Nigeria, you can tell that there is a major fight back. There's a media war against the fight against corruption. You will find people who will put stories in the media that suggest that there is something wrong with fighting corruption. People will tell you, for instance, that, look, it's all media trials. That is a media trial. I don't know what that means. If you discover, for example, large sums of money are discovered in a place, there is nowhere in the world where it will not make the news. There's nowhere in the world. If you go and find somebody who puts large sums of money in an air-conditioned room, there's nowhere in the world where it will not make news. There's nowhere in the world. So this whole idea of trying to delegitimize the anti-corruption struggle is definitely fueled and funded by those who have these resources, who have stolen these resources. And I think it's important for us to understand that unless we see it as an existential problem for us, unless we as Africans, we as Nigerians see it as a problem that can bring down all of our systems, we're never going to be able to fight. We're never going to be able to fight against corruption. And I think that this is a point which I hope we will be able to advance, especially with other African countries. If you look at the Thabo Mbeki report, the Thabo Mbeki report shows that most of the illicit financial flows that come out of Africa come from Nigeria. And that is, so evident in some of the figures that they give. And I think that shows us very clearly, especially those of us who are concerned with law enforcement in Nigeria, that we simply have to do more. We have to work harder, because it is evident that so much money is leaving our shores, so much money is leaving our resources. I was arguing with a certain gentleman who works, a friend of mine who works with one of our development partners, about their stopping funding for a certain project. I don't want to describe the details, so you don't know who it is. But so he kept telling me about how, well, Nigeria is no longer a poor country, we're now a middle-income country, that kind of stuff. So they shouldn't really be giving us those types of grants and all that. And I was quite, and I of course insisted that even before you cut off those kinds of flows, you must give us notice, this and that. Finally agreed that I had made a sufficiently good point and that they might consider continue to give the money. Not so long after that, in fact, I think it was barely a week after that, when some large sum of money was found in Kaduna, which was roughly about half of the money that we were asking for. So he sent me this text, which showed just a text that said this money had been discovered somewhere. Of course, I didn't reply the text. Then he sent it again, I didn't reply. Then I called him, is this your idea of a joke or what? I mean, but clearly, there's something to be, it is sometimes absurd, when we are asking for aid, and this comes back to the whole idea of the SDGs. When you're asking for aid and so much money, much larger sums of money than the aid you're asking for, is actually going out of the country. So I think that there's a sense in which we ourselves must take responsibility for our problems and ensure that we do something about it. Having said this, I will close by commending this initiative of the Presidential Advisory Committee Against Corruption in collaboration with the Ministry of Foreign Affairs, the Ministry of Justice, and the government of the Kingdom of Norway, and of course all our development partners and institutions who have worked hard to bring this event to fruition. It is now my special pleasure to declare this conference open. Thank you very much.
Oshimbajo. SAN just declared the event open. You re-emphasized the fact that Nigerians need to collectively come together to fight corruption. Otherwise, it will fight back, especially if it has a safe haven. Having declared the event open, it will now move into technical sessions where important issues, including the program now moves into technical session, including practical steps to stop illicit financial flows, enhancing asset recovery and asset return, management and application of returned assets for SDGs and human rights, and also framework for international cooperation. But this is the point where we will be ending this outside broadcast. And on behalf of the crew, I say a very big thank you for watching. My name is Sheon Ogunluyi.